Actually, this litigation is directed towards WhatsApp, but the bill deals with Miller's intermediaries throughout the system. So, Miller, it's not a WhatsApp-centric litigation.
You got a copy of the bill, actually?
I've got Miller's, yes. In fact, I have formulated something for your lordships to consider. We just hand it over to your lordship.
What we would have to see perhaps is
yes.
that in the ambit of the bill,
yes.
versus the scope.
In fact, we have made that table.
Only a minute. One request I would earnestly make. The bill is to be introduced in the House.
Oh.
Please do not permit anyone to discuss the bill. It is the House which would discuss the bill. We can't discuss it here.
So if you say that, equally, they may say that we are in a limbo and we will not make progress in this case. How many times it has been?
Yes, we made a table.
That's for your lordships to decide. I am only, my apprehension was.
It is not even in an embryo stage.
That's entirely your lordship's call, my lord. The only thing was that since it is coming in the second half of this session, it can wait for a few weeks more. That's all. But I can't, my lord, if he is. I am supporting Mr. Diwan. I am finding it really difficult to support him.
Mr. Mehta,
you had filed an application. You had filed an application.
Yes.
I have filed an affidavit, my lord, pointing out this fact that subject to. I'll just
the copy, the affidavit is here.
Yes.
It says that a bill was circulated for public comment. Comments have
let me read the
being collated.
I'm sorry, my lord. I kindly allow him, my lord. Kindly allow me to help you, please, sir. My lord, this is what I have said, my lord. But I further state and submit that with a view to lay down a comprehensive legal framework governing digital personal data protection in India, MeitY, that is the Ministry of Information Technology, etc., has formulated a draft bill.
Even if it is placed, can we make any observation touching that? It is a prerogative of the Parliament.
It would be, Lord, it would be. We can't, at least, we can't, Lord, on this side discuss on. That debate has to take place.
It is there, not here.
Parliament. MeitY has formulated a draft bill titled so and so. MeitY initiated a stakeholder consultation exercise on the draft bill, inviting comments from the public from on 18/11/22, the last date for receipt of which was 2/1/23. MeitY is in the process of collating and analyzing the feedback and suggestions received with a view to take the draft bill forward. I further state and submit that as is evident from the above steps taken by so and so, subject to fulfillment of procedural requirements, intends to introduce the aforesaid bill in Parliament at the earliest. This was as on 11 January. Yesterday I received instructions that subject to fulfillment of adverse administrative requirements, it has to be routed through cabinet, etc. Subject to that, we intend to introduce in the second half of this session. Second half starts from 13. So as to perennially keep the matter pending. That's all.
Well, it's quite a part.
Mr. Solicitor,
yes.
See, bill is yet to be introduced in Parliament.
Yes. Lord, I'll just tell your Lordship, Lord, second part of the budget session is from 13th March to 6th of April.
So, is there any harm in our hearing the matter?
Lord, there
is
no harm, Lord. Your Lordship can always.
I would like to respond to that.
There is no harm, Lord. My answer is straight. There is no harm. But if the petitioner's concerns are not taken care of by the bill, by the act, my lord, if it matures into an act, then, my lord, to a large extent, some extent, my lord.
The problem which we possibly can anticipate is in the event we decide the matter in one way and
the bill, my lord, actually deals with.
Yes, my lord. Then, my lord, it would be a second round of litigation.
That is a speculative measure.
Lord, in fact, your lordships, my lord, our assistance would also be by and large academic and speculative.
It's anticipated collision, not a.
No. I'm sorry. No, I'm saying, my lord, our submissions would also be more speculative than, my lord, having any legal framework before your lordship. Anyway, my lord, if it can't wait for 3 weeks, it can't wait.
My lord, I can only say this to your lordship, my lord. This issue was dealt with in Puttaswamy. 9 judges of this court. My lord, and I show your lordship the paragraphs on that way.
So if this has already been decided on that basis.
No, not decided. That Malad commented upon that as far as non-state actors are concerned, it is better that the bill, Malad, is formulated by Parliament before the court deals with it. That's what Puttaswamy says.
24th August.
If you please allow me, sir, there's no point of intervening. I'm just pointing out what 9 judges have said.
No, now there is a constitution bench decision delivered last week or 2 weeks back, in which 19 and 21 it has been held. That is enforceable against non-state actors.
No, true, no doubt, Malad. Nobody is disputing that. But what 9 judges says, this is such a complex area. And it has such complexities that court is not in a position to deal with these complexities unless the bill is before you. That's what 9 judges say. I'm not saying that, Malad. So I just wanted to point out to your lordship. See, Malad, paragraph 304 of Puttaswamy.
By the time the judgment comes, Malad, the apprehension is, would Malad be justified in preempting the debate which is to take place in Parliament?
Not only that, Malad, much of what your lordship,
not that your lordship cannot.
much of your lordship will be doing will be an academic exercise because the bill is overtaken, Malad. The problem.
What is the clash?
The clash is, Malad, every aspect of their.
We cannot look at the bill itself.
No, please look. I don't mind, Malad.
No, Malad. I think, Malad, your lord.
Part of the legislative process.
So it's not introduced yet. So there's just a bill which was circulated to the public for comment. That's very different from what will eventually, if at all, introduced in Parliament, which the Solicitor General applies upon.
It becomes property of the Parliament after introduction.
In any case,
Lord, if we are being that technical, Malad, your lordships can even set it aside. That don't intrude.
No. We want to see
whether
there are.
The subject, I've seen it, the subject matter of the bill is exactly the claims that they have made.
yes,
See what
so I'll just indicate broadly as to where we are.
How many cases are there?
There are 4 shown on the call in the cause list. There's 502, 502.1, 0.2, and 502.3.
What are the petition numbers?
Yes, now 502, which is the case where I appear for the petitioner, is an SLP Civil 804 of 2017. That, as I indicated, is what arose from the judgment of the division bench of the Delhi High Court.
Okay.
Then there is 502.1 shown as connected.
So that is from a 226 petition.
It is from a 226 petition. It's a petition which, in one sentence, challenges a specific change in policy which occurred in the year 2016. That was subject matter of the challenge. That it continues to be the subject matter. And we'll indicate.
Is it a live issue today?
It's an absolutely live issue today. It's a live issue today. There are subsequent developments to the 2016 policy, which we will also be placing before the court.
In a minute, what is your complaint actually?
Yes, the complaint in a minute, if I have to say that, in a minute, the petitioners before the High Court and now the petitioners before your lordships were WhatsApp users. They're citizens of India, and they had subscribed for this internet-based messaging service, which your lordships are probably familiar with, on a basis and a representation of what the extent or what the then privacy policy is or was. That policy underwent a dramatic change, and the change which occurred included, amongst other things, that WhatsApp would share certain elements of data, both personal data as well as metadata, with what I will broadly describe as the Facebook group of companies. So Facebook at some point had purchased WhatsApp, and they now said that they would utilize or pass on this data also insofar as Facebook is concerned. That was the subject matter of challenge as to whether this invades privacy rights broadly in a very, very general sense. What the High Court came to the conclusion was that, look, as far as privacy rights are concerned, that matter, as your lordships correctly observed, was still at that time pending before this honorable court, because it's a 2016 impugned judgment. Your lordship's judgment sitting in a panel of 9 is 24th August 2017, which is the judgment Mr. Sibal referred to, which said, please consider bringing in a data protection law. So that's more than 5 years ago. Anyway, keep that aside. So then the High Court held that, look, privacy, we are not going into it because it's a little uncertain. They cast doubt, which I should indicate to the court, with regards to the maintainability of the petition, qua private parties, etc. Then proceeded to give an exit. And they said that, look, within 2 days or 3 days, If you wish to exit user of WhatsApp, then you may do so. And in cases such as that, as far as WhatsApp is concerned, they will not share the data, they will destroy the data. Those details I will get into. The WhatsApp and Facebook have accepted the judgment of the High Court. They haven't come up over here challenging that particular judgment. In the meanwhile, when this matter came up here before the court, the bench presided over by Chief Justice felt that this was an issue which deserved to be decided by a constitution bench, and therefore it fixed the matter and constituted a constitution bench. The matter has been heard on occasions as recorded by this court's order in the past. Last it came up effectively in the month of September last year when a similar request was made. At that time, it was hoped that the new bill would be introduced in the session which was around Diwali, etc. And they were, everyone was hopeful that that would happen. As it came to pass, that did not happen. The bill, the original bill which was introduced. So after 2017, a bill was introduced for, generally I'll describe it as data protection. That bill came to be withdrawn by government itself. There's a further public consultation process. I might also add that the earlier bill which was passed and which was eventually withdrawn was also referred to a committee. So that's also something your Lordship will keep in mind, because it's not as if the moment a bill gets introduced, the Parliament, as the court correctly observes, has its own processes, etc. So my challenge is essentially directed at this action which took place in 2016 by a radical change in policy, and that policy itself has evolved. The limbs of my challenge are many. I first say, and it's going to be our submission, that insofar as the law laid down by this court in Puttaswamy is concerned, this would violate those particular foundational principles. Now, whether those foundational principles and the extent to which they finally become law and how they are applied, etc., is Parliament's prerogative. We are not going to go into that at all. So that's one limb of the argument. The second important limb of our argument is that WhatsApp operates across several jurisdictions. When it operates across several jurisdictions,
Europe versus America.
Yeah, it appears to have a certain differential standard when it comes to an individual user's privacy.
Which should
So,
not be.
for example, you cannot have a situation. You cannot have a situation where, yes, I'm sorry.
Two questions.
Yes.
One, you have an SLP against the judgment of the High Court.
That's right, which is now before you. That's one. That's my case.
That's right.
The others will tell you.
What did the High Court do?
Yes, so what the High Court, as I told your Lordships, was that it rejected the challenge. However, it gave an exit. The exit option which was given to users was that if on or before a particular day, you stop using WhatsApp, etc., then your data will be deleted, it will not be shared, etc., etc. So there were certain directions which were given up that side, which
Take it or leave it. That was.
Take it or leave it.
Right.
Now, if today we are granting, we are allowing your SLP.
Correct.
That we are allowing the SLP.
Correct.
So forget about the billing.
Right.
So what is the relief that we can grant?
Yes, so there are declaratory reliefs which we are seeking. The declaratory reliefs are, and I'm again broadly indicating to the court what those are. With that, so simply because I have already articulated this point, that you cannot share my data with the Facebook group of companies. So we seek a declaration to that effect, or at any rate, at a minimum, an opt-out option. Because what you will find when we explain the case, several users in other jurisdictions are given a meaningful option. When I say meaningful and informed option means that there are clear instructions. And if those instructions are followed, a person has an option to say, sorry, I want to opt out insofar as this type of sharing arrangement is concerned, or not sharing arrangement, which is not available to users in India. It ought not to be, if we are correct, eventually to persuade the court.
Was it tried as a public interest?
No, it's an individual. It's a user. So there is obviously a public interest angle to this. There is a public interest element to this, but it's also by an individual user who says, sorry.